Let's say a young couple signs their marriage papers and think that they have finally entered a private, peaceful life. But somewhere else, in a government office, that same marriage can suddenly become a legal argument about religion, inheritance, and who gets to decide what family even means. One bill can turn a home into a constitutional battlefield. This is not a dusty legal debate for law students. This is about your marriage registration, your daughter's inheritance, your divorce, your maintenance rights, and the rules that decide whether two people in the same country are treated equally or differently just because they were born into different communities. Article 14 of our Indian Constitution promises equality before law. Article 15 forbids discrimination on grounds including religion, caste, sex, and place of birth, while Article 25 and 26 protects religious freedom and the right of religious denominations to manage their own affairs. That is exactly why the Uniform Civil Code debate feels so explosive. It sits at the point where equality and diversity collide. Let's go back to the year 1948. India had just been born out of partition, and the constitution makers were trying to build a country that would not tear itself apart from the inside. In that room, the constitution was almost like a nervous architect. It wanted one nation, but it also knew that India was not one religion, one custom, or one family structure. Article 44 was the compromise they placed into the constitution, a future goal for a uniform civil code. Not an immediate enforceable right. The debates around it were intense because critics feared interference in religion, while supporters argued that unity and women's right could not wait forever. That is the first important thing people forget. Uniform Civil Code was not inserted as an overnight command. It was placed inside the directive principles, which means the state should strive for it, but it is not like a fundamental right that a citizen can directly enforce in court. The constitution was basically saying, yes, this is very important. No, we do not yet have an easy political path to get there. And that unfinished sentence from 1950 has been haunting Indian politics ever since. Now fast forward to today, and this conflict is no longer theoretical. Personal laws still govern marriage. They govern divorce, they govern inheritance, adoption, and maintenance across communities. And here's the first surprise. Schedule 7th places marriage and divorce, adoption, wills, and succession in joint family and partition in the concurrent list, which means both parliament and state legislature can legislate on these subjects. So when a state like Assam moves on Uniform Civil Code, it is not stepping outside the constitution, it is stepping into a constitutional space that already exists in our country. And Assam has now done exactly that. On May 25th, 2026, the Assam government tabled the Uniform Civil Code bill in the State Assembly. Now reports say that the bill is expected to be taken up for discussion and passage on May 27th. The proposed law is not a giant code covering every possible civil issue. It is focused mainly on a minimum age of marriage, prohibition of polygamy, equal inheritance rights for daughters, and live-in relationships, including registration-related issues as well. Now, religious practices are being kept outside this particular scope, and scheduled tribes in hill and plain areas are being exempted. This is what our Honorable Home Minister also discussed about when he remarked about Uniform Civil Code. Now, that leads to the second surprise, and it is one of the most uncomfortable one. If large communities are exempted and religious customs are protected, then what exactly is uniform about that code? That is the real political question beneath the legal language. A bill can sound like a single law for everyone, but once exemptions enter into the picture, the debate shifts from uniformity to selective reform, and that is where the real fight begins. There is also a third surprise from the states that moved first. Uttarakhand was the first state to implement a Uniform Civil Code law in 2025, and the state later said that more than 4.74 lakh marriages were registered digitally within a year. Supporters use that figure as a proof that Uniform Civil Code can simplify civil administration and can make registration easier. Now critics, though, hear something else in the same number. They say not just reform, a huge expansion of the state's role in private life is there because of Uniform Civil Code. So what is India really deciding here? On one side, the argument is brutally simple. If the constitution promises equality, then why should a woman's civil right depend on the religion which she was born into? Why should inheritance, divorce, or maintenance change merely because the family belongs to a different faith? That is why Article 14 and 15 kept coming back into this debate. They are the equality behind the entire argument. But on the other side, the constitution also protects religion, and not in a symbolic way. Article 25 protects the freedom to profess, practice, and propagate religion subject to public order, morality, health and other constitutional limits. And Article 26, it protects the rights of religious denominations to manage their own affairs. So the legal tension is real. The state cannot say religion matters when it wants votes and then say religion doesn't matter when it wants control. The constitution forces both values to remain in the room at the same time. This is also why the courts matter so much in the Uniform Civil Code story. Since Shah Bano case, the Supreme Court linked the issue of maintenance for a divorced Muslim woman to the larger question of a common civil code. In Sarla Mudgal, the court again pressed the government to take Article 44 seriously. And in John Vallamotum, the court struck down a discriminatory succession rule on equality grounds and again noted the larger civil code debate. The message across these cases is consistent. Personal law can exist, but it is not beyond constitutional scrutiny. So here is the line that actually matters. A uniform civil code is not about making every Indian the same. It is about making the law stop asking your religion before it asks your rights. If the code is truly about equality, then it must protect women, simplify civil life, and survive constitutional scrutiny. But if it becomes a selective political tool full of exemptions, symbolism, and fear, then it stops being reform and starts becoming a theatre. So the real question is not whether India can have a uniform civil code. The real question is this: can India create one civil law that expands equality without shrinking trust? Or will every attempt at uniformity end up looking like a new name for old divisions? This is the question which I'd like to ask you. Do answer it in the comment section. I'll be very happy to read your comments. All the very best. Have a beautiful day. Thank you.